Friends, our today's topic is regarding res judicata, which is explained in section 11 of the Civil Procedure Code 1908. So normally the doctrine of res judicata, according to section 11, it says that the court will not take up any suit. That means no suit shall be tried which is already substantially and directly decided. That means a decided matter will not once again be taken up. This is the intention this is done with the intention to put an end to the litigation. There are so many concepts or legal maxims for this doctrine of res judicata. So the most important one is ex capito res judicata. This is Roman law. One suit and one decision is enough for any single dispute. For any single dispute, one decision is enough. You need not bother the person by filing another suit under the same conditions. The second legal maxim is nemo debit bis vexare pro idem causa. That is, no man should be vexed twice for the same cause. We will discuss the same according to the constitution also, and even in CRP is also stated. At that time we will discuss. Then the third legal maxim is res judicata pro vericate occipiter. Pro vericate occipiter. A decision, judicial decision, must be accepted as correct. That's all. There is no place for the second decision. And there is another concept also. Actually, this is also one of the most important concepts. This is intereste republicae quod sit finis litium. That means there should be an end to the litigation. In the interest of justice or in the interest of state, there should be an end to the litigation. With these four legal maxims, the doctrine of res judicata is applied. Simply to say that where a matter has been decided with the same parties or with the same title or with the same dispute, then there should not be another case. The other case will not at all be accepted, since the previous case has been directly and substantially decided. Right. Coming to the constitutional part, Article 20, Clause 2, it says that no person shall be prosecuted and punished for the same offence more than once. This is what we call as a double jeopardy. Double jeopardy. A person should not be vexed by filing too many cases on the same topic. Either he may be prosecuted or punished, both. That means section 10 also, res sub judice also applies. Anyway, let us confine to res judicata. Then coming to the part of Code of Criminal Procedure. Of course, this applies to the CPRPC, not to the CPC, but here let us know this provision also. According to section 304 CRPC, it lays down that person once convicted or acquitted should not be tried for the same offence. In other words, we call it as artifice acquit and artifice convict also. So these are the legal maxims or theory behind the so-called res judicata. Now coming to the provision of section 11, already we have stated no court will take up or will try any suit which has been directly and substantially decided between the same parties or between the parties litigating under the same title. Of course, there are 8 explanations for this also. Explanations are not the emperor. First of all, please learn the doctrine of res judicata or the rule of conclusion of judgment as to the point decided in a it may be either points of fact or points of law. You are well aware what is the question of fact and question of law. For example, if you take A takes an amount of 10 lakhs from B and executes a promissory note, that he would repay the same with interest of 24% or so. But even the period of limitation is going to be completed, that is about 3 years also, he is not paying back the money. Now therefore A files a case against B for relief, specific relief that the money should be repaid to him with interest. Now there are two facts here, question of fact and question of law. The court will decide regarding the question of fact whether A is liable to pay amount to B or not. This is a question of fact. What is the question of law? Whether it is a legally enforceable debt or not. Suppose if the period of 3 hours limitation is over, then he need not pay. This is according to law. But according to fact, he has to repay the money. So if it is decided by matter of fact, question of fact or question of law, this is equal. So no double jeopardy. Once a matter is finally decided by, here remember, it's a competent court. When it is decided by a competent court, definitely no party can be permitted to reopen it in a subsequent case, in a subsequent litigation. That means if that is not done, there is no end to the litigation. So the doctrine of res judicata is conceived in the larger public interest, which requires that all litigation must sooner or later, definitely it should come to an end. So it is also in the ancient Hindu principles or ancient Hindu law, it is called as Purva Nyaya. It once decided, then they will not take up the matter. This is in Hindu law, it is called as Purva Nyaya. There are certain conditions, of course, I have given in the section itself, but there are certain conditions to frame the so-called res judicata. Condition number 1 means that the parties should be the same. Parties litigating under the same title. The parties should be the same. There may be their legatees. If the A dies, then his legal representative can take part in the litigation. And the second point is the matter should be directly and substantially decided. There should be no doubt. There should be no collaterally or incidentally. It should not be decided. It should be decided directly and substantially. Then the court should be a competent court. If it is not competent court, then the difficulty arises. You have to file in another court. So the court should be a competent one. These are the conditions for the res judicata. Right? So there are 8 explanations for the res judicata. I will give you an example. Detailed case laws are there. You can get the internet. But let me give an example. Suppose A files a civil suit against B for eviction of B under Rent Control Act. So B is staying there. He is not paying any money. So A wants to get him back, to evict him or to vacate him from the house. Now what B will do? B has proved that A is not the owner of the house or owner of the land. What happens? The suit is dismissed. Is it not? Now A cannot file another suit. A cannot file another suit either by himself or through X for the same cause. Here he wanted for eviction. Now he cannot file a case for drawing a rent of some amount something. So B should not be punished for the same, because already it is decided that A is not the owner. He could not prove it. Of course, there is another example I want to give you. Same case, A filed a case against B for eviction, saying that he is the owner. B proves that A is not the owner. Subsequently, A gets the ownership from his ancestral property. Then now A can file another case, because now he is the real owner or legal owner. It is not barred by res judicata. Right? Second example, res judicata applies even to the writ petitions also. Normally, we will be filing writ petitions under Article 32 before the Supreme Court and Article 226 of the Constitution before the High Court. So, res judicata applies to the writ petitions also. When we discuss about explanation 6, we say that if it is the public interest, even 100 people file the petition, then only one case will be taken up. So, according to the explanations, explanation 1 says there are definitely 2 courts. So now a case has been filed in one court and another person files the case in another court. Whatever court gives the judgment early, that judgment will be taken up. Even though he filed the case at a later stage, if the judgment is given earlier, that is the competent court. And secondly, of course, regarding explanations, please remember, explanation 4 is most important. That is called constructive res judicata. Constructive res judicata means if you want to file a case against on one condition, then you cannot go for the second condition. I will give you the same example. A files a case against B for collection of rent under Rent Control Act. Actually, B is staying in the house or flat of A for 3 years. But somehow, A wants to recover the rent for 2 years. Now, he files a case against him. He stated that he wanted to recover the 2 years rent. Fine, that's over. 2 years rent was granted. The court decided in its favor. Right. Now, once again, A cannot file another case against B that he wants to collect 1 year more rent because he has been staying there for 3 years. That means this is a constructive res judicata, and in evidence you can call it as estoppel, doctrine of estoppel, all these things. That means if you want to take a claim it in the first instance itself. That's why while telling order number 2, framing of the suit, the whole claim should be put at one place, but you could not give piecemeal judgment or piecemeal litigations. That's why already we discussed in so many things. I discussed about that departmental proceedings case also, that in the first instance he says that he was not served with the copy of the so-called charge memo, and the principles of natural justice were not followed. Nawaz Hussain versus State of UP. So even though the department proved that he was served with the charge memo copy. Now he filed another litigation that it is the IGA police who appointed him, and therefore DIG is not competent to remove him, to dismiss him. So this should have been stated in the first claim itself. He cannot go for the case in the second time. Like this, writ petitions, public interest, only one will be taken. Even though 100 people file the same petition, it will be taken up by only one. Like this, so many cases are there. So, res judicata restrains a person from filing another case under another section when the parties are the same, when the matter is the same, and when it has been directly and substantially adjudicated. Thank you.